Okay, so I've just turned the recording on, so why don't we go ahead and begin? Thanks everyone for coming out today from hosting from Canada, but from also from all over the world for this next iteration of the Tort Law and Social Equality Project speaker series. We're really lucky today to have Professor Cristina Tilley join us. Professor Tilley is Professor of Law and Claire Ferguson Carlson Faculty Fellow in Law at the University of Iowa. But for 2024, 2025, as we discussed, she's a fellow in law and normative thinking at the Princeton University Center for Human Values. Um, Her scholarship is really on point for this speaker series since it investigates theories of interpersonal obligation as a foundation for comparing how private and public law can drive social justice. She's written broadly on topics of tort law and constitutional issues such as sex equality, free speech, and privacy, which has appeared in venues such as the Journal of Tort Law and the Yale Law Journal. Um, Recently, in a commentary on Joseph Ranney's recent book, she's been turning her attention to the history of American tort law, examining tort law's historical foundations as rooted in concerns about social justice, which will be roughly the topic of her talk today on tort originalism. So, Professor Tilley, you'll have about 45 minutes, give or take, for your presentation, and then we'll open it up for Q&A. So, thanks very much, and take it away.
Great. Thank you so much, Anthony, for inviting me in. And it's so nice of you all to show up to chat with me about an early stage project. It's really, as Anthony mentioned, I'm in Princeton this year, and my project for the year is a book project examining the social justice potential of tort law. But the piece I'm going to talk to you about today is kind of I think the necessary predicate for talking about the future of tort law is to kind of talk about the past of tort law. And why is that? Well, one of the things that I've discovered being in a new city and at a new institution this year is that I'm getting introduced, several times a week, and I have to sort of sing for my supper and explain what it is that I work on. So around academics and lawyers, I'll say I do tort. Around non-academics and non-lawyers, I'll say I do personal injury law. And I typically get one of two responses. For the academics, they'll say, oh, so you're an economist. And for the non-lawyers, they'll kind of make a disaffected face and say, oh, you study ambulance chasers? And even, in this group where I think we share interests and sympathies, the website, suggests that tort is a body of law that can reify social inequity and that it's sort of inherently regressive. So I would put all those reactions together into a basket I might call tort prejudice. And I have kind of come to the conclusion that before I can open the minds of readers to have some blue sky thinking about the future of tort, I need to first attempt to destabilize or dislodge some of that tort prejudice. And the project today is kind of an attempt to do that. So first, I'm going to talk very briefly about, why I think this kind of prejudice or fixation on tort as a quasi-regulatory economic body of law has such a grip in modern discourse. Then I'm going to present the results of a study that I've done, a founding era tort law, to kind of try to push back on some of those dynamics. And then I'm going to wind up by talking about, how both tactically and instrumentally tort might be repurposed to be more of an arrow in the social justice quiver going forward. So I think if you were to ask most law students, lawyers, lay people today, what is the body of law that is primarily responsible for advancing social justice and protecting individual rights? They're going to point you to the Constitution. They might then, depending on how aware they are, also, make a little bit of a face and say, for now, or it has been, because as we know, the modern Roberts Court has been following a new mode of constitutional interpretation, one that relies very heavily on original public meaning, as evidenced in history and tradition, to kind of roll back a lot of the social justice and individual rights landmarks of the late 20th century. Even people who are aware of that dynamic, though, never will point you to tort. They will never suggest that tort has the capacity to sort of fill what today is becoming a constitutional vacuum. And why is that? Well, I think one of the reasons is that, as I'm sure everyone on this Zoom knows, we're in the middle of something of a Cold War in modern tort in Canada too, but in the United States, I think, in a very pointed way. On one side, you've got economists who think that the goal of tort is to efficiently allocate resources and create an optimal market economy. On the other hand, you've got corrective justice and civil recourse theorists who think the tort is about doing interpersonal one-on-one justice. So the former camp tends to be the camp of the economists, and the latter is the camp of the philosophers. And as, again, I'm sure everyone on this call knows, the economists are winning. At least in the United States, that is the prevalent understanding of tort, is that it is a tentpole of the modern political economy. And so what is the econo-theory of tort? Well, it centers accidents that harm body and property as the problem to be solved, or the place where tort is brought to bear. It treats as the important kind of accidental behavior, negligence or unreasonable behavior. It equates reasonable behavior with the taking of cost-justified precautions. And it says that if a precaution is not cost justified, taking it is a suboptimal allocation of resources. So it's very much about, as Scott Hershowitz has said, the perception is that tort is just about moving money around. Why has that theory exercised such an iron grip on the modern academic imagination? I think one of the primary reasons that it has is that it is accompanied by a cognate econo-history of American tort. And notably, the historians who are producing this scholarship are also the theoreticians for the most part. They're not historians by training, although nor am I. They are economists, judges, and lawyers. So what is the econo-history of American tort? It tells us that before the mid-19th century, American tort practice was totally insignificant. The date that tort arose varies depending on who is telling the story. The earliest it has been said to have arisen is in 1820. Joseph Ranney tells us that. Posner says it arose around 1875, but everyone agrees there was, no tort at the founding to speak of. To the extent there was interpersonal injury litigation at the very earliest part of the country's history, these scholars dismiss it because they say it lacked a unifying rationale. It wasn't doing any single thing. It just has no internal coherence. It has been called a crazy stew, a wacky soup, a dog's breakfast. And thanks to that history, which I will say the philosophers have done a great job parrying the econo theory of tort, but they haven't, and I love the philosophers, but they haven't really attempted to parry the econo history of tort. And this, of course, makes sense. There's in some ways thinking in the abstract. They are, they're not interested in tort as instrument. And so their theory of tort kind of floats above time and place. But as a result of that, we have a story that tort is and always has been, that its sort of real and natural province is as market actor or market savior. So John Fabian Witt, I think, summarizes this point of view very well when he says that, American tort is almost entirely a product of the late 19th and early 20th centuries. It was only then that accident rates of an industrializing economy required the development of this body of law to deal with these injuries and accidents. So that, has all the concepts wrapped up there, right? It gives us the time, it centers accidents, it centers in industry and the economy, and tells us that is really what American tort was made for. Well, if that's the case, if tort is market savior, then almost by definition, it is being depicted as social justice villain. And I think you see that also as a theme in a lot of tort scholarship. It started out illiberal and remains unprogressive. It follows capitalism's drives and allows great wide suffering. It reinforces systemic forms of injustice in the larger society. So I think, as long as that is the paradigm in the popular or the scholarly imagination, you're not going to get very far telling people that the social justice hopes that are being dashed in the modern constitutional age can be revived in tort law. Before you can do that, you're going to have to at least soften this kind of acceptance that tort is all about the market and not at all about individual rights. So my project is really an attempt to look at the history and ask whether there's an opportunity to push back on that understanding. So most of the histories that have been done, as I mentioned, really concentrate on the post-industrial era. What I've done in this project is look at pre-industrial tort, which I have defined as 1790 to 1820, stopping at that earliest date of modern tort that Joseph Ranney gives us. And what I did was look at all of the state court reporters that have been recently made available in Harvard's Case Law Access Project. They have digitized every available reporter, really from the pre-founding era, although I only started in 1790. Georgia and Rhode Island have not been digitized for this period, but the remaining 11 states at the founding, we've gone in and looked at all of the cases in those reporters. To get a reasonably usable data set, I dropped all of the odd year cases. So the remaining cases, the even numbered cases from all of those 11 state courts, there were about 7,000 of them, 7,000 and some. Of those, I cut away all that had as a party the state, the Commonwealth, or the people, to try to cut away the public law cases. What's interesting is, as you'll see, wait a minute, there are only about 500 public law cases, and the remaining 7,000 or so are all private law cases. So I wasn't setting out to interrogate the balance of those two kinds of cases, but I think that in and of itself is an interesting piece of data. Okay, so if you go and look at the remaining 6,934 private law cases, what you find is that 29% of them sounded in tort, and the remaining 71% are divided among contract, property, and estates. So that's that also, I think, is just in a very broad way, useful information to have. Now, we can go further, and we did, and we looked at all of the tort cases that we could find, and we categorized them. What kinds of cases were being brought during this 30-year period? 33% of them were property torts. Another 25% were ejectment torts, which nominally or in reality involve landlord-tenant cases. Now, sometimes the landlord-tenant configuration was a fiction that allowed boundary challenges, but oftentimes it wasn't. It was an actual landlord-tenant dispute. 18% of the cases were classic intentional torts to person, battery, assault, false imprisonment, and so on. 14% of the cases were negligence. Now, a chunk of those involved common carriers who handled cargo, typically, allegedly in a careless fashion. But about half of those were negligence cases being brought against sheriffs and constables with the allegation that in executing a writ to recover property or to bring a debtor or typically an enslaved person in for custody, they carried out that authority in a careless way to the detriment of the property owner or the creditor. 7% of the cases were cases against sheriffs and constables alleging not careless behavior, but intentionally wrongful behavior in the form of malice or self-interest. And then the last two slices of cases, they're very small, but they wind up being significant. 2% of the cases were designated replegiando homine, which is a subset of the replevin tort that is used to challenge the legality of one's being held in custody. And these were brought by enslaved people. And then finally, 1% of the cases were libels for divorce. At the time, the states did not typically have statutory public law regimes governing divorce. Divorce was a subject of the common law, and the granting of divorce was conditioned on allegations and a finding of some kind of marital wrongfulness or injury. So again, in these libel for divorce cases, you have spouses, typically women, claiming that there was some kind of marital wrong that took place that entitled them to be freed from the bonds of marriage. So those are the categories of tort cases that are being alleged. So I think, first of all, we can see the tort practice was not, in fact, totally insignificant. It was quite significant. It was at least 1/3 of what was being litigated in state courts. It potentially is more significant than property, contract, or estates. If those are divided somewhat evenly, tort would actually have the lion's share of the docket at this time. Now, was tort, though, this incoherent, chaotic, wacky stew that the historians have told us that it is? Looking at this pie chart, your first answer might be, yeah, it kind of looks pretty splintered, right? These cases are dealing with fact patterns ranging from, unreasonable uses of the land to marital abuse to, slanderous words. What do they have in common? Well, again, if we return ourselves to the worldview at the founding era, we would consult Blackstone. All of the founding era lawyers looked to Blackstone to understand the common law. And he told us that individuals all had rights of persons actionable against other persons. Those rights break into three baskets. There's a right of personal property, a right of personal security, and a right of personal liberty. And if you reorganize the tort cases, you'll see that they map on almost exactly to the rights of persons that our Blackstonian founding era lawyers would have recognized. So you see there's a whole list here of property torts that are being used to vindicate property rights. There's a whole list of intentional torts that Blackstone describes as the tools to vindicate security rights. And then there are the false imprisonment, sheriff malice, and replegiando homine cases that are being used to vindicate liberty rights. The libel for divorce cases and the seduction cases that you find in the founding era, I didn't put into any one of these baskets because they have elements of multiple baskets going on. So I've kind of separated them out to be a little bit principled about it. But you can see that they could fit into multiple baskets. Libel for divorce, there's a property aspect to it. There's a liberty aspect to it. Depending on whether there's physical abuse involved, there's a security aspect to it. Seduction was typically pled by fathers on behalf of daughters, or making the case that they had been deprived of services from the daughter. So it technically is understood as a property right claim. But you can see that in the seduction cases, typically the fact pattern involves a daughter that's been debauched and often impregnated. So there's a security, element to those cases as well. But in general, the point is that, what might at first blush look incoherent and splintered actually does have a legible internal logic. This array of writs is really just being used to vindicate the rights of persons that founding era lawyers would have readily identified as security rights, property rights, and liberty rights. We can also do, because this is a searchable database, we can do a little elementary corpus linguistics with these tort cases to see, what are the concepts that founding era courts are referencing when they're adjudicating tort cases. And the one that emerges as the most referenced concept is the concept of rights. 6,439 references to rights are found throughout this database of founding era tort cases. Close behind are references to the jury. Courts are very much interested in what the jury did. The vast majority of these cases were heard in the first instance by a jury. And as we'll see in one of the next slides, founding era courts considered the jury to have a unique function and a unique role in the identification and vindication of individual rights during this period. If we look at the Blackstonian concepts of the rights of persons that are being protected, we see property far and away is referenced the most. Security it comes next, and then liberty. As I'll discuss again in some of the following slides, the property cases do have elements of individual rights to them from time to time. So that's worth understanding. I also was very interested from as an originalist observation to see that, relatively speaking, liberty was sort of the least weighty of the rights of persons. So to the extent there is, again, sort of a popular perception of private law as libertarian, the history is, ambiguous on that point, ambiguous to unsupportive, I would say, on that point. It seems less interested in individual liberty than it does in individual rights to security of personality, meaning the body and sort of dignity. We see that along with multiple references to rights, courts are also interested in the idea of wrongs. What kinds of behavior count as invasions of those rights of personality? Courts are also very interested in the concepts of the neighbor, the community, and society in sort of filling out and giving meaning to the open textured concepts of rights that are being litigated. And we see a substantial, I think, number of references to feelings, dignity, humanity, and sentiment resulting from acts of outrage or oppression, a concept that I'm going to return to in a minute. Okay, so who is being talked about in founding era tort cases? Not all of these references are to these members of these identity groups as litigants. Sometimes they're involved in the fact pattern, but they're not actually litigants for various reasons. But it does give you an idea of, who is populating the world of tort during the founding era. The most referenced actor during founding era tort is the sheriff or the constable. This is not surprising because in the era before Fair Isaac and a privately moderated sort of credit market, creditors typically were enlisting the support of sheriffs to recover debts, to recover property, and, as we know, to pursue enslaved people when they escaped the bonds of slavery. So sheriffs and constables come up a lot in these cases. But there are substantial numbers of references to women. And I haven't broken this down, but it's interesting that the words used to describe women, yes, sometimes they're described just in their sort of abstract capacity, but they're often described in relational terms. their relation to a father, their relation to a husband. And the word femme typically comes up when the court is distinguishing between a femme covert and a femme sole, meaning a married woman or a single woman, because of course that can have legal implications for her rights to sue in her own behalf, own property, engage in contracts, and so forth. So that comes up a lot in the cases. Almost as often, American founding era tort judges are talking about Negroes, slaves, and mulattoes, and those are the words that they used. So I would use different words from my presentist perspective, but these are the words that the courts are using. Sometimes those individuals are litigants. Sometimes they are parties on whose behalf a suit is being brought. Sometimes a suit is being brought against an owner of an enslaved person for the behavior of that enslaved person. But you see that the status, the rights and the social status and the legal status of these individuals is a subject of great interest to founding era courts. Of slightly less interest are economic actors. So almost evenly divided, debtor and tenant, creditor and landlord. So there's a lot of concern with those economic power relationships. And then just as a sort of baseline, I think the word that during the founding period maybe best captured white male was freeholder. And you see that there are far fewer references to freeholders. And again, I mean, we could draw a lot of inferences from that. The inference I would draw is that they are sort of, in the legal imagination, they are the foundational person. So, they don't have to be given an identity because they are the assumed identity of most litigants, that courts are sort of calling out when identity departs from the norm. So we don't see quite as many references, not nearly as many references actually, to freeholders. Okay, so what does this empirical evidence tell us about American tort history? I mean, I think it very plausibly punctures, if it doesn't totally refute, it at least punctures in a meaningful way the claims that early American tort was insignificant and incoherent. It was a third of all private law litigation in the founding era. It was a thriving pillar of the civil docket in the very earliest years of the country. And it did have a coherent internal logic. It was a vehicle for the vindication of rights of persons when they were being denigrated by other persons in the community, including property rights, security rights, and liberty rights. So is it really a dog's breakfast? Or maybe we could describe it as the breakfast of champions, if we're being glib or clever. Okay. Narratively, I'm kind of going from the numbers down to the words used, and now I want to spend just a little time looking at kind of the narrative passages in some of the cases to give us an even more nuanced flavor of what the courts are doing. Ordinarily, I wouldn't put so much text into a PowerPoint. I know that's not best practice, but I do think the words are important here, so I wanted to throw them up, and I'll kind of read or reference them as I'm talking through them. One of the things that emerges very strongly in reading these tort cases is that the courts understand tort as a body of law that is meant to be flexible and adaptive. They will often say, well, the rule is X, but here we're going to apply it in this way that we haven't before. Sometimes they'll say, we're actually going to bend the rule a little bit, or we're going to, adopt a corollary rule. And they will say, we're doing this because law reflects policy and we want to adapt it to our local situation. The law has a great regard to usage and practice of the people. It is nothing else but common usage. And it alters with the exigency of affairs. To sum up, one court says the law is stable in its principles, but it's flexible in its application so that it can meet every new case that may arise and provide a redress for every injury that may be inflicted. So they are, holding space for tort to bend and adapt and, update its notions of what the content of rights are and what kind of behavior counts as a wrong against those rights. Now, who is providing this normative updating function? For the most part, it is the jury. So we have courts saying a jury coming from the neighborhood has a great advantage as an essential operation in preserving public order, enforcing private justice. It diffuses amongst all classes of the community reverence for the laws, without which liberty is but a name and security a shadow. So we see here again, they're speaking the language of rights of persons as Blackstone gives them to us, liberty and security. They identify the idea that it is the people within the local sociological community who are best positioned to understand what is going to preserve public order, what the local people want or need, and what is considered interpersonal, private justice between people within that local community. It is the law alone, says another court, it's justice and humanity and the integrity of a jury which can repair the wrong done. So again, we're alluding to flexibility, we're alluding to the jury's sort of primacy, and we're talking about the idea that we're concerned with wronging, we're concerned with interpersonal repair of wronging, we're concerned with justice, we're concerned with humanity. All of the concepts that to our presentist minds, echo in social justice and so forth. Okay. How is this actually being applied to members of various identity groups? Black individuals. I pulled out just a few representative cases. There are a lot of false imprisonment cases in which enslaved people are contesting their enslavement. One of them involved a girl who, when she was 12, found a baby, a Black baby in a barn, and she took him into her custody, and he is now suing for his freedom. And the court says that the woman eventually grew up, treated the plaintiff with humanity, but claimed him as her slave, a sort of indication that enslaving somebody sort of falls short of full humanity. And then eventually this enslaved person won the case and won their freedom. Another false imprisonment case brought by an enslaved person, where there was some lengthy litigation and a continuance. The slave owner was instructed by the court to give bond to make sure that he would bring the plaintiff back to court when the time arose, rather than taking him out of state. And during the pendency of the suit, to treat him with humanity. So again, there's some ambivalence there to our modern ears. Saying hold this person as a slave and treat them humanely falls short of what we would consider genuine social justice. But at the same time, there is wrapped within this language some awareness of the fact that humanity is a pressing concern that the court is trying to guarantee here. In trespass cases, oftentimes a trespass case would be brought by the owner of a slave for the behavior of a third party towards the slave. One of these involved a sheriff who allowed a party of deputies to recapture an apparently escaped slave. Once they recaptured him, rather than just bringing him back into custody, they assaulted him, beat him, physically were quite violent. And the constable just stood by and allowed it. And the court says that's a wrong. If he allowed the slave to be beaten, he counts as a trespasser and he's liable in tort. A similar case where a third party unrelated to a sheriff physically assaulted a Black individual, the court says both policy and principle require that Black lives should be protected from the attacks of the violent and unthinking part of the community. So again, we are referencing community norms to identify, what enlightened individuals within the community would do versus what unenlightened or unthinking individuals in the community would do. And then the court amplifies, says, whether considered as persons or chattels, the common law applies to them. There again, that's an ambivalent statement, right? It is allowing for the possibility that these enslaved people are not persons, but it's also saying that the common law and the capacity for equity to be vindicated exists, regardless of what label is being used. So ambivalent, but again, holding space for a good outcome. In a case where a neighbor broke into a widow's house and again assaulted and beat her slave, the woman sued on her own behalf for trespass to land, for the neighbor coming into the property. But lurking was her dissatisfaction with the neighbor's treatment of the enslaved person. The court here says that slaves don't have any personal rights, so it's only through the medium of their owners that they can receive that security and protection for their persons, and it would be a reproach to the state to withhold that from them. So again, invoking those Blackstonian ideas of security, saying that the dignitary entitlement of enslaved people means that they do get some security. That ambivalent piece being, well, they can't do it for themselves, so they, this person who's claiming ownership to them has to do it. So it's again, there's a discomfort there, but there's a piece of it that is forward-looking. There's a piece of it that's acknowledging the dignitary interests of people in this class. And then finally, slander is used in a lot of cases during this period to kind of survey the community sentiment about where various people fit into the social hierarchy, because the main question in slander cases of the day was whether the words the defendant was alleged to have spoken would be actionable. And they're only actionable if they would cause the community to think less of the plaintiff. So here we have a case where a defendant said someone was taken up a few nights ago playing cards with a Negro person in the neighborhood. And the jury found against the defendant, and the court says, well, no, the relationship wasn't criminal, and so nobody would think less of someone for engaging in this non-criminal interracial relationship. So we're adjudicating those status relationships there. You see some of the same kinds of conversations about the status and the rights of women. Again, comes up a lot in the divorce cases. Many of which involve allegations of cruelty, abandonment, adultery. In the case that I've pulled out here, a man apparently was a, regular adulterer and contracted a venereal disease. When the wife sued for divorce, he asked her to please identify as the wrong the adultery and to not mention the venereal disease. She agreed, and he said he would pay her some extra money if she would do that. And then, of course, after she got the divorce, he didn't pay her. So she winds up suing in qui tam for fraudulent conveyance, saying that he didn't pay her and actually gave his money to his father so that she couldn't reach the money. But it was an opportunity for the court to kind of weigh in on some of these issues. And the court says, no, you have to pay her. And one of the reasons is that the court identifies that the wife has no means separate from the husband, that they certainly simply can't generate wealth outside of marriage on their own for the most part, and that's a reality that has to be dealt with in order to give the wife some kind of foothold to personal security. Again, we've got a slander case where someone was alleged to be with the child of Stephen Jones. She's an unmarried person. And the court says, well, those words are really not actionable, but, and here you see the court, adapting tort. The court says, but the charge is so odious and detestable and so likely to be injurious, not just to the woman, but to the peace of society, that we have much pleasure in declaring the action maintainable, because it's an atrocious injury and the laws just simply have to respond to it. So they're kind of, they're nudging the law in this forward direction, although it hasn't operated that way in the past. And again, seduction cases often involved women and reflected, sometimes internally inconsistent feelings about the rights of women and their place in the larger society. The very fact that it was the father who typically was suing in these instances and not the woman is I think, of itself interesting to observe. Of course, why is the woman not suing in these cases for assault or battery? Well, because consent would come into issue, and that was not something that the women of this period likely wanted to litigate in public. So the father instead would sue. So we've got a situation here where the defendant was said to have made an assault on Sarah. He beat her, wounded her, and ill-treated her. He debauched her, carnally knew her, and impregnated her. And after she gave birth, a few months later, she died. She had a very difficult childbirth. So, the title of the tort is seduction, but that sounds a whole lot more like rape to me. And so you've got the court kind of dealing with the outcome here. The court says a couple of interesting things. First, it acknowledges that although technically this has been conceived as a property tort where the loss of services is the real injury, the court acknowledges that the mental pain the parents feel that their child has gone through something like this, that is really what's being vindicated here. So that sounds pretty forward thinking in some ways, to acknowledge that there's an emotional component to sexual assault experienced by someone. I mean, I think obviously the woman more so than the parents, but at least the court's acknowledging it. But then it backtracks and says, but in this case, the father was alive when the rape happened. So it was his injury. The mother, as a femme covert, didn't experience the injury at the time of the rape. The father died after the childbirth. So the mother is the only parent living at this point, but the court says at the time the injury happened, she had no legal personhood, so she can't bring the case. So again, there's, it's one step forward, it's one step back, it's all in the same case, but the court is indicating some willingness to kind of hear and think about the dignity, rights, and the social status of the people involved. We see the same thing happening in cases of debtors and poor people and workers. A debtor's house was broken into by a creditor. He sued in trespass, and the court said absolutely not. That violates the right of domestic privacy and security, which the laws have always manifested a scrupulous anxiety to protect, so protecting a debtor. A replevant action against a debtor by a landlord that was sort of summary in its fashion. The court rejected that, saying you haven't given the debtor an opportunity to come into court and have it proven that he actually owed this debt. And that is, we don't make a distinction in favor of creditors who are landlords. In a case where a minor apprentice left the employ of an employer and the employer refused to give him his clothes and his coat, a sheriff went with him back into the house to get those items, and he sued for trespass, for replevin. And the court said, absolutely, the sheriff should have participated in this, that the child needed the items. And then finally, you even get sort of a foreshadowing of public accommodation law, where a man of bad reputation was denied entrance to a local tavern. He broke down the door so he could get in, and the tavern owner sued, and he was ultimately held liable. But it's this interesting case where the court is asking whether every individual has a right to go into property that is technically privately owned, but that is so essential to participating in the social life of the community that it is functionally public. So it's kind of an early version of public accommodation law. And you see there are a couple of other cases involving balls, which made me think of Jane Austen and kind of the right to go into a ball. Okay, and then finally, there are a couple of cases involving sheriff wronging, where a sheriff was sued for trespass because of his deputy's conduct. And the deputy went between 10 and 11 o'clock at night and proceeded in a rude and insolent manner to carry out the levy. The jury awarded high damages, and the court said, that's just fine. We're not going to say that's excessive. The quiet of the plaintiff's family was invaded at a very unusual hour of the night. and the jury are making an example of him, and that's just fine. Now, this, I think, again, is sort of an early iteration in tort and not within Fourth Amendment jurisprudence of sort of knock and talk rules, and whether that can be conducted at nighttime. So we see that those kinds of rights are really thought to belong in tort and not elsewhere. And again, where a sheriff seized goods of a debtor, and then rather than selling them and giving the money back to the creditor, he just used them for himself. He converted them to his own purpose. He was sued for conversion, and the court called his behavior a gross act of oppression and injustice. So here again, we see that sheriffs are being, curbed in meaningful ways by the standard law of tort without any reference to the Constitution. So I think, when we look at all that, it's plausible to ask whether we now have something of a justice history of tort to accompany the justice theory of tort. So we're meeting the econo-theoreticians and we are meeting the econo-historians on equal terms at this point, now that we've got a fuller picture of early tort law. We've got a history that accompanies philosopher Scott Hershowitz's view that our human dignity allows us to move through the world as equals, and that tort is designed to protect this sort of dignity. Okay, so where does this cash out in the present day? And how does originalism come into it as a theory and not just as a way of referencing history? I would suggest there's an argument to be made that tort actually has pride of place in the US Constitution. Now, some people have suggested that substantive due process in the 14th Amendment allows a right to sue in tort. I would locate that right potentially in the Ninth Amendment, which has been a puzzle to US constitutional theorists for a long period of time. The text of the Ninth Amendment, just to get us all on the same page, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. If you do, so first of all, if you use an originalist theory of constitutional interpretation and you're asking what's the original public meaning of this text, according to the history and tradition of the time, the understanding of rights at the time the Constitution was drafted was very Blackstonian inflected, and Blackstone recognized that dignity rights could be just as invaded, if not more invaded, by the behavior of fellow private people than by the behavior of the states. If we accompany this with a little etymological investigation, what we learn is that the word certain at the time of the founding was more often used to designate the concept of fixedness than the concept of select versus general. I think our presentist understanding, we read certain rights and we think, well, that really means some rights. But the original public meaning of the word certain is closer to fixed. So the Constitution enumerates some fixed rights, but that should not be construed to disparage other unfixed, fluctuating, adaptive, evolving rights retained by the people. I think there's a plausible case to be made that these unfixed, fluctuating rights retained by the people are those rights of persons protected by tort causes of action when the Constitution was drafted. And I'll highlight for you a case that I think kind of illustrates this possibility. So a propertyless Quaker in Pennsylvania had been conscripted by his local militia, but of course he resisted because it was against his constitution and his religious principles. A group of deputies came into his house without permission. They threatened to billet themselves there and eat his food and drink his wine until he complied with the conscription order. And then eventually they took his person and brought him into custody. He tried to vindicate his rights, and he did so in state court, alleging what the court calls the mere torts of trespass, assault, and battery, very clear that his religious liberty was at stake, very clear that his right to be free of an unreasonable seizure was at stake, and pretty clear that his right not to have soldiers quartered in his home were at stake. But the First, Third, and Fourth Amendments never come into the conversation as necessary or relevant. The entire conversation revolves around tort law and his personal rights within tort to be free of this kind of deputy action. Okay, so if you're willing to take the leap with me that the Ninth Amendment really creates a freestanding center of gravity for individual rights, unrelated to and unreliant on the 14th Amendment due process and equal protection clauses, and if those Ninth Amendment tort rights are to exert some kind of freestanding power in this space, what exactly would that look like? I mean, how would they be used? What rights are might be vindicable through tort as an originalist interpretation of due process and equal protection kind of decay? I think there's a whole list of them potentially. Hate speech could be the subject of intentional infliction, privacy, defamation, litigation, social media aggression and falsehoods, again, and by this I mean sort of revenge porn, doxing, that type of thing, intentional infliction, privacy, defamation, gun behavior, careless gun behavior, not necessarily the subject of state regulatory legislation, which is going to encounter some Second Amendment problems these days, but ex post, negligent storage cases, negligent supervision by parents cases could have some power in this area. Police misconduct, which today is viewed almost exclusively through the lens of the Section 1983 statute, which incorporates the Constitution and constitutional rights as vindicable through this sort of hybrid constitutional tort mechanism. As we know, this court is expanding qualified immunity principles in such a robust way that 1983 is functionally unavailable to most plaintiffs. What is available? Intentional infliction, assault, false imprisonment, trespass, all those cases that were being brought against sheriffs in the founding era, where the privilege concepts are quite a bit different than the qualified immunity jurisprudence that the Roberts Court has developed. What I would call non-collaborative sex, you might call it rape or sexual assault. I think calling it rape and sexual assault reflects a sort of regulatory criminal law approach to it. I think that, you know, the more capacious concepts of negligence and strict liability in tort allow for kind of a fresh look at relational obligations within sexual relationships and the obligation to collaborate and what collaboration by sexual partners looks like, and can kind of modernize those norms with some jury input in a way that criminal law has not meaningfully done. Equity in middle spaces like the office, the bar, the gym, the park, microaggressions, basically. Very effectively, I think, vindicated through intentional infliction, negligent infliction. Again, sometimes assault, battery, or false imprisonment, you know, if it's physical sexual harassment in the workplace. Artificial intelligence, which is the subject of a lot of regulatory energy these days, just as easily could be held within tort. I've written elsewhere about a theory of strict liability for artificial intelligence as an abnormally dangerous undertaking. I won't get into all of that here, but I just think there's, you know, there's a rich potential for tort to operate in this space. Now, is it going to occupy the entire space? Dobbs is very much on everybody's mind today. Is tort going to be effective in the reproductive area? Maybe, probably not as effective as it might be in some of these other areas, but, you know, to the extent that, you know, reproductive care is, you know, discretion is being exercised in various ways, and possibly there's an opportunity there. I think it's really less applicable there. So I want to be honest about the potential, I think, for tort in this area, but I do think it's a rich potential. The question then becomes, though, is tort up to the job today? And I think the answer is not yet. It's not there yet. And why not? And what can we do to get tort ready for this important work as the Constitution becomes less relevant in this area? Okay, one of the reasons that tort is not yet, I think, up to the job has to do with the development of the rules of civil procedure over time. The authors of those rules tended to be legal realists. They tended to accept the econohistory and the econotheory of tort. And so as a result, what they really appreciate and fashion and want to accomplish, especially in cases involving repeat corporate defenders, is efficient, quick resolution of these cases, typically by judicial summary disposition, usually in summary judgment actions where the court is declaring as a matter of law how the defendant should have behaved, basically setting forth judicial regulations for corporate behavior, and short-circuiting jury input into what that behavior should look like. As long as, we have only, I think the figure is something like 0.5% of civil cases going in front of a jury, using tort to modernize norms by activating community impulses or community common sense is not going to work. So I think to kind of interrogate the transsubstantive assumptions underlying the rules of civil procedure and to suggest that tort is actually a different body of law than some other bodies of law that are being civilly litigated, and it might need its own set of procedural rules to kind of decenter judges and recenter the jury. I think that is kind of a precondition for deploying tort in the way I imagine. And then I think the other big impediment to doing social justice through tort in the modern era has to do with injury doctrine. So starting in about 1870, state courts began to say that emotional injury on its own, with no physical injury or property injury, the law simply didn't take cognizance of and couldn't compensate. This is the Lynch v. Knight rule for people who are, deeply immersed in this area. But Lynch v. Knight presents this as, a long-standing historical, rule with real deep pedigree in tort history. And as we know from the sort of corpus linguistics slide where we pulled out the concepts of feelings, dignity, and so forth, courts were regularly giving awards for emotional injury. Reimagining or recapturing early injury doctrine to recognize the reality of intangible, non-physical, emotional, or social injuries, again, is sort of a precondition to building out a really vibrant tort law of social justice. Now, here the news is better because the American Law Institute is, as we speak, doing a restatement of remedies, and early indications suggest they are taking a more capacious and flexible approach to emotional injury as real and compensable, even when it's not parasitic on some kind of injury in the physical world. So that's kind of, the springboard for the balance of what I hope this book will be, which is thinking about how we can repurpose tort in the present. But I think, I feel like I need to kind of clear out this the underbrush of the assumptions that we make about tort theory and tort history before I can feel good about making a forward-looking case. So it's a lot, and I know some of it is making a leap. So I'll be really I'll find it super helpful to get feedback and talk with you more. So I'm going to stop the share so I can do that.
Thank you so much, Christina. So that's just a fascinating project. Looking forward to the ultimate book and reading the ultimate book when it comes out, when it's ready. I have tons of questions. I think it is a very rich presentation. So why don't I invite others first while I maybe I'll put myself on the queue afterwards. But questions from others. Okay, Sarah.
Hi, so thanks so much for sharing this fascinating project. I have sort of a mishmash of questions and comments. Um, Maybe I'll just piggyback off one of the things you said at the end, sort of how there's sort of in the ether these assumptions about tort law. And I would encourage you to maybe be more explicit about where they come from, right? Because they didn't just like evolve out of people, right? They really were part of a concerted political project spearheaded by tort reform, by ALEC and things like that. And so it was a little disheartening at the beginning to hear how successful that project has been when you sort of explain the project or what you do to people and they have what people who are in tort reform would be delighted to hear their responses of ambulance change scene and sort of this illegitimatization of tort law itself. So I would just be more explicit that it's arising because of this concerted effort to make it arise. It's not arising from sort of impulses within individuals or even within the collective unassisted. When you showed the pie chart of private and public law, my question was going to be, which bucket are you putting in lawsuits against by private people against public actors? And then you sort of answered that when you got into the sheriff's cases. But I just thought it was a really interesting moment, again, of sort of things that are right on that line of using private law against public actors for public purposes. And so it sort of could be in either bucket. And so just another interesting place where that happens. On the Ninth Amendment issue, there was a recent paper that I thought might have interesting analogs for you, and you might have seen it as well. I think I saw it on the Legal Theory blog about how the United States Constitution incorporates a backdrop or a subterranean level of international and customary norms, and it was understood that those were sort of incorporated into the Constitution, even though they're not explicit in there. And so that seems like a really similar maneuver to what you're talking about. It has sovereignty in the title, but I forget it's a 3-word title with the word sovereignty in it, and it's about those international norms. So I think that could be really interesting for you. And then the other thing that piece made me think about was just the role of state constitutions and how so many of them do have explicit protections for tort law in there, and sort of some of the interactions between those, I think, could be a rich area for an already, of course, incredibly rich project. But thank you so much.
If by rich we mean verbose, yeah. Um, okay, so a couple things. Yeah, the assumptions. I think it's fascinating. Actually, what I'm kind of envisioning, and I'd love to have sort of a prologue, and I've started looking into this a little bit, kind of really focusing on the phrase ambulance chaser. Because I think that is the primary, like that has been, you're right. So rhetorically, like such an effective tactic, and it's very interesting in my preliminary research. The first time I find it used in the United States is in the New York Sun in 87. And it's during that period of time, the owner of the New York Sun had been progressive, but underwent something of a like political, I don't know what. Enlightenment is not the right word. What's the opposite of enlightenment? But he became like kind of virulently conservative. Um, and so you see this phrase getting used a few times in the Sun. It like gets picked up by all these other national papers that are obviously just doing pickups of the New York Sun reporting, and it kind of takes off from there. And then the next big blip of the phrase ambulance chaser comes in like the 1920s in the New York Times, because the Association of the Bar of the City of New York is doing like a whole project investigating ambulance chasers. And the people on the committee, it's fascinating because it's Cadwallader, Taft, it's all the names of the big firms today who are on the committee, discussing ambulance chasing. And again, I've just started poking around, but from what I can tell, Adolph Oakes, who was the publisher of the New York Times at the time, was social friends with the person who wrote the ambulance chasing report at the time that the word takes off in the New York Times. So Yeah, I'm hoping to look into the archives of the Chamber of Commerce and maybe even the ALI to kind of, trace the use of the word over time and to get at what you're talking about. Because I agree with you. It's not an artifact of nature. It's a very designed kind of prejudice. I agree with you. Uh, the lawsuits against public actors. Yeah, I should talk more about that. In my text, I write about it a little bit, but I should think about it a little bit more. I mean, what's interesting is, as you know, is that sheriffs, it's mostly sheriffs, some constables, but sheriffs at this time, they did occupy this weird space where they were not fully public actors and they were not fully private actors. They had this public role. They lacked discretion for the most part. They were just supposed to be carrying out these judicial orders, and their pay didn't even really come from the state. It tended to come from like a lot of fees from the private individuals on whose behalf the writs were being executed. Um, so they are this, like, they sit in this twilight space. So you're right. Plausibly, some of this stuff could be put in the other basket, and maybe just have two pie charts to kind of show that would be a really good and helpful thing. Um, but what then I think is interesting is that there is like really no public law to constrain them. Even if we call them public actors, the only law that's constraining them during this early period is the private law of tort. So that is maybe even a stronger case. Um, for a sort of, and the sheriff cases tend to be very pro-civilian. The way that some of the other, like the women cases are not always pro-woman, the cases for enslaved people are not always pro-enslaved person, but the sheriff cases tend to be much more tilt in a much more pro-civilian way. So that's interesting. Yeah, the Ninth Amendment. I mean, the Ninth Amendment is, I put it in here because I think it's the springboard to thinking forward. I think really it's a whole article and a whole chapter on its own. I think there's a lot more to be said and delved into. And one of the things that I think is interesting about what you've said about how it kind of is an incorporation by reference of international customs and norms. I just heard a paper the other day with somebody saying that kind of making the same argument that we don't need the court to interpret substantive due process and equal protection in a human rights fashion, because all it needs to do is look at the UN Declaration of Human Rights, which has all of those concerns baked into it, and which is legislatively refutable. So he was saying that it gives Congress a way to sort of shape what those rights look like through the vehicle of international law. And I found it so interesting that he's looking to what I would say is like a higher level of law or a more remote level of law to inform what dignity is, whereas I want to go in the opposite direction and look to the like most ground level place of the jury. I mean, it doesn't have to be either or, but it is interesting, you know, um, to think about sort of spatially, where do you go? Yeah, super interesting. Um, and the state constitution, it's in the sheriff cases and some of the other cases where you would think that they'd be looking at state constitutions, that doesn't come up much either. It does come up occasionally, but not as often as you might think. So yeah, interesting to think about, and I agree with you. There's more work to be done in those areas.
Thanks, Sarah. Eric?
Yeah, thank you so much for your talk. And I apologize that I have a hard stop very soon, so I'll have to jump off. But I just wanted to ask you that this concept of dignity in early tort law, uh, it's interesting because it precedes the explosion of dignity in like the post-World War II era. So I was wondering if you could speak to whether you see any differences between the concepts of dignity kind of like evoked in like Rochin and like the post-World War II era and what we're finding in like these early tort cases.
You mean like what? how what the content of the dignitary rights
Yeah,
are.
like like in the post-World War II era, we often talk about like cruel, inhumane, degrading treatment. But like there are also older conceptions which talk about like dignity as status, like dignitary harms that like seem to have been brought out in the like Lawrence cases like later on. And I'm wondering like to what extent like is that are you seeing that holding constant? Like we're not talking about torture, we're not talking about bodily degradation like in the early tort cases, and instead we're talking something more like status degradation.
I I would say I think we're talking about both. I think it depends on the identity of the person whose dignity is under discussion. So, like for women, it tends to be status degradation. For enslaved people, it's bodily, bodily torture. Like there are so many cases saying, well, it's, certainly sometimes you have to use like physical discipline um, when you've got an enslaved person to, for the work. Um, but gratuitous physical discipline is not permitted. So again, like I feel uncomfortable saying some of these things because they really, to our modern ear, do not sound like they're vindicating dignity. But they are saying that these people are entitled to physical security in the Blackstonian, to and that going beyond the quantum necessary to achieve whatever the discipline is meant to achieve is a kind of inhumanity and a kind of indignity. Um, and I would say for most of the other categories of people, it tends to be more status degradation. Um, I mean, I think one of the ways that I might put it, and I'm not sure if this maps onto what you're talking about, but is that my impression is that sort of post-war conversations of dignity tend to be like dignity in the abstract, like that there are categorical notions of what dignity is, whereas I think in this early period, dignity is understood very much in relational terms. There is not some sort of categorical abstract quantum of dignity everyone gets. It's sort of between these two people, what happened and at what point did it cross the relational, the line of relational equity between them. Even if they occupy different parts of the hierarchy, there's an expectation that they do owe each other something and that can be breached. Even if it's not, pure status equity, there is an expectation of some kind of obligation for some quantum of respect between them that can be withheld. So sorry, Eric.
Hey, he's got to go. But maybe I'll try to channel and just to sort of on this topic. So when I think of dignity, one there's kind of, so I guess, two ways of looking at it. Maybe a modern conception of dignity is uh, a sort of sense of universality. That is this quality that every human being has that doesn't depend on their social station, or how much money they have, or the social groups they belong to. Um, and that seems to be a kind of modernist conception. It's like a universal declaration. And an older version of dignity might be a ranking-based one. So it was a sign of dignity as kind of nobility or aristocracy, something like that, dignity as rank, uh, where now, like, the modern era is bringing people to that level. I actually think I read in some of those quotes that you provided some conception, when, especially the notion of humanity. So you have right at the beginning, the conception of a slave being treated with humanity, yet being still treated as slave, where there's this idea that, regardless of our rank, we have this universal quality that we all share. And, the idea that we can all be vulnerable to emotional distress, for example, even if we can't sue in the case of women. So I wonder if, like, tracing backwards the notion of dignity as universality might be helpful to see some common thread. Just a
Yeah.
suggestion. But so I'll in the last little bit, I'll try to ask my questions because I did have a lot too. Um, I guess I had like two buckets of questions. One of them looking at this, I think you wanted to refer to it as kind of like a destabilizing project to uh, give a kind of counter narrative to the econo historian. So I think I'm like Hershkovitz, like a philosopher looking for the historical support. So what I want to ask is maybe like some people that how somebody might doubt that historical support, even given the story that you told. So maybe one thing is like I think that like my sense is that, and maybe you disagree with this, but my sense is that if we were to kind of do this empirical analysis of the modern tort law,
Mhm.
we'd find like a good smattering of cases that fall into some of those categories that you mentioned towards the end, like the uses of IIMS or IIMD for these kind of social justice oriented causes of action, that sort of thing. But I still think an opponent might say, well, does that mean that uh, our current tort law provides support for the social justice theory of tort law, just from an empirical perspective? I guess I wonder whether like, are we just dealing with a kind of idiosyncratic subset of founding era torts? Or like what makes us think that this is representative of tort law? This is somehow fundamental to tort law? Because I think somebody who's skeptical, a skeptic might say, well, this is kind of peripheral or aberrant, or like this is not really what the core of torts is about. It's still about and it's an economic point of view. So I think that was just a big picture question. I wonder what you say about this.
Um, so this is interesting because there's so much there's so much here. So deciding like how to extract data or what to do that's gives a picture and what is a principled picture. I've been sort of like building and wrestling with how to do that. Um, so I think, you know, the way I've tried to do it so far is to say, well, here are the numbers. And then there are like a lot of references to property, right? So that kind of supports an economic account. Um, but there are lots of references, more references to concepts that are not property that I think tells us I'm not like I think in the narrative sections I am cherry picking a little bit, to try to give you a sense of what the courts thought tort was capable of doing. And there are cases where people of marginalized identity groups lose, and there's like bad language, that suggests that's not very good, nice, dignified about them. And then there are also cases where that doesn't come into issue at all. So yeah, I acknowledge in the narrative part. I think if what you're suggesting is I've picked some things that support my thesis, yes, I have in the narrative part. I hoped that the data in the pie charts did not lead to those same kinds of claims. Because I'm showing exactly what was being litigated. And I hope that the corpus linguistics, again, was a little bit transparent. But what I've been wondering, and I think this kind of gets to your point, and I don't know what I will find, is whether maybe the thing that you would find persuasive on this point would be if I went into, say, all of the ejectment cases or all of the property tort cases and looked at how many of those involve some kind of either involve a person who is in the economically powerless position or a woman, because a lot of them are like um, about whether the woman was devised land by her father or whatever. If I kind of broke down the identity characteristics within those each section, especially the sections that look more economic from the outside, to say, no, underneath the economics, look, this is what's going on identity wise, or to say, here's how often dignity or whatever is mentioned even within the economic cases. I don't know. Would you find that to be more, that I'd be more of an honest broker in supporting the thesis with the data
So
if I did
yeah, I guess
that?
that's like who's making use of these concepts maybe is one. I think yes, but I think that I wonder whether a different tactic might work, which is again looking at this from a larger abstract perspective, is to say, because even today, I don't think anybody wants to deny that part of tort law has an economic function, right? Like right? So it's more of like a pluralist picture, not a monistic picture that to
Yes.
entirely displace the economic view, is to say, and I think a nice way that you put it at the beginning was, it has this economic purpose And our critical eyes shouldn't just be looked at the regressive possibilities of of torts while it's pursuing these economic purposes, but like also the progressive possibilities. And to establish that it could have a progressive possibility from a historical point of view is to say it always had a progressive component. It was never that it was all about the progressive point of view, and
Okay.
right, and it was never that it was never that it never had a regressive side. So I guess my second point was going to be like somebody could equally say, and now so I'm thinking of two things. I'm thinking of um, Goldberg and Sapersky's view of the value of civil recourse as like a kind of voting right in a way. We didn't get that in the founding era. In fact, like I think what you documented is courts trying to get around that problem, that like the slave couldn't sue on their own behalf, but they require the solicitude of their master's property rights to protect their humanity. So um, in a way, so there's a regressive function of torts built into that very idea. Like it's because there's the fact that people don't have equal civil recourse. And I'm also thinking about Eric's talk last on 1980 section 1981 that I know we were both at. He's documenting the history too of the greater access to disenfranchised groups to to civil recourse as well. So part of the story too is like we're always going to be starting from a regressive standpoint if we're looking at the pre-founding era. But even even within you can even say, even within the most oppressive conditions imaginable, where torts is not even available to everybody, there's still recognition, like there's this spark, right? There's this ember of the idea that it's not just that the regressive potential of torts needs to be avoided, but that we can actually positively advance social justice. So I think
Yeah.
putting it this way would allow you to frame the historical narrative in a really kind of more compelling way, it seems to me.
Interesting. So you're saying it's not really the data that you want more of or different slicing and dicing. You feel like framing it in a different way, in a way that is more willing to acknowledge some regressivity and to put the progressivity into context would be more compelling to you. That's helpful. That's helpful to
I
know.
mean, from a kind of qualitative or humanities-based perspective, as opposed to I still think the slicing and dicing is useful, right?
Yeah.
Um, but like if the package, I think would be
Mhm.
helpful. I think really the key to it is what you said right off the beginning. I think you had a term called like the tort prejudice, right? Like the tort prejudice is that somehow even amongst social like so Chamalis in the social justice tort theory article makes this point that like a lot of the even the tort law social justice tort law scholarship is kind of deconstructive. It's saying like the conception of the reasonable person has historically been, had a disparate impact, so and so on. But not a lot of it has been constructive. But and so I think there's some kind of effort to get to the constructive point in your project, and I think
Yeah, yeah,
it's that we need to find in the historical narrative, which I think is there, like it's there.
yeah.
Uh, yeah.
No, that's super helpful. Um,
Well, maybe in the last 2 minutes, just for the sake of getting more on the table, uh, just looking at the future project, I would say that like maybe tailing on this point I just made, like what seems to be, and there was a particular quote from one case talking about injury, emotional distress being the focus of injury. Like, I wonder whether you can point to the historical tort material to say the injury doctrine has never been so hard baked into tort law that there's never been potential for recognizing emotional injury. There's lots of evidence of that.
yeah,
That's really helpful. Maybe
yeah.
the bigger point I wanted to mention though was, yeah, I think it's a great the decentering of the jury, right? Because it does seem like there's a lot of kind of community values coming in through the jury. But like, are there modern doctrines that allow that? I just wonder if the doctrine of public policy is what we should be looking for here. And I actually don't know a lot about it. Like, so can you found a cause of action on like conduct that is contrary to public policy. Because that's another, even if the, so if that's kind of replacing the role of the jury with a doctrinal rule. That
Oh, see, no, that's so interesting. But that kind of goes back to the conversation with Sarah in this paper about, where do you get the norms? Do you go up to, some even more remote document or concept? So I think the answer or an answer is like in the third restatement of tort, there's a whole section, and it doesn't get cited very much, but that says, when can courts resolve a tort case on summary judgment? It's when like custom and practice is so clearly resolved that judges, can just go ahead and do what the jury would have done, is basically. And it says, when and when they're different, when it's not resolved, judges should sort of, law should lead the way, right? So, and I have a big problem with that, with the idea of saying that judges get to determine, what custom is, how resolved it is, or even what public policy is, right?
Right.
I think they can have, all the good faith in the world, but they just occupy a different space in life than most of the people who would be seeking the social justice or the equity. So I am deeply uncomfortable with using a concept of public policy applied by judges versus actually delegating it, devolving those questions to the jury. And I think that's part of what I was pushing back on in Eric's paper, was this idea that 1981, sort of gives us this national public policy on what contracting norms must be. Because I think that 1983 in the police context tried to do that, tried to say, well, the Constitution and judicial interpretation of the Constitution tells us what policing norms are going to be. And, the minute it went from tort instincts applied by juror civilians to, constitutional instincts applied by privileged judges, the idea of what was normatively acceptable for police to do changed a lot, and not in the justice direction, in the other direction. So that is, that's why I get deeply uncomfortable with ideas of introducing public policy. They're especially in an age of judicial capture.
Right. Okay.
But anyway, that's my take on that. But the idea of being deconstructive versus constructive, that's hugely helpful to think about. And the voting rights concept is the equality concept. But see, even there, like the voting rights piece of it, what I find super interesting is that, we are equating, we are, it's premised on this assumption that social justice is like a civic justice or a state project, right? But it's right there in the name that it's social justice. It's a sociological project, to have one-on-one individuals, outside the confines of the state, actually giving each other respect in gyms, in workplaces, and so forth. That is not, there are limits to how much that can be a state project, I guess, is what I'm saying. So you could have voting rights or not have voting rights. You could have voting rights and still not have an experience of interpersonal dignity, the voting rights as they're conceiving of them, right? And you could also not have voting rights and actually experience some kind of interpersonal dignity. And I think it's a subtle difference, but it is a qualitative difference.
Yeah.
So I don't know.
That's all really helpful. We're out of time. I do have more questions, but we can maybe stop the recording and allow people to sign off. But thank you very much, Christina. It was an awesome presentation. Looking forward to more of your work. So thank you very much.
Thank you, everybody. Really appreciate it.